Raise your right hand, please.
Can you ask him to raise his right hand?
右手举起来。
Do you swear or affirm to tell the truth and nothing but the truth, so help you God?
我如果條嚟見你哦，你負責。
Why?
Yes，
Put your hand.
舉手嚟啊。
Mr. Weiss, will you stand to make sure the translator hears your shirt?
Are you the father of Jason Chen?
女人嘅小老爸。Yes，
Is there anything you want to say to the family of Jasmine Pace?
呢度 Jasmine family 有冇宣告什麼話？
我都可以講，對這兩個係我聽教嘅非常抱歉。
We understand your hurt and we are so sorry for your loss.
No further questions?
Okay, any questions? All right, thank you. You may step down. Any other witnesses for the defense? State off in your rebuttal.
No, Your Honor.
Members of the jury, evidence in the sentencing phase of the trial on count 1 has been completed. It's now my duty to instruct you as to the law. The law applicable to the sentencing phase of the trial on count 1 is stated in these instructions, and it is your duty to carefully consider all the instructions. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but you should consider each one in light of and in harmony with the others. Having found the defendant guilty beyond a reasonable doubt of first-degree premeditated murder of Jasmine Pace, as charged in count 1, presentment 315228, you now have the duty to determine within the limits prescribed by law the penalty that shall be imposed as punishment for that offense. In Tennessee, the possible sentences for the offense of first-degree murder include imprisonment for life and imprisonment for life without possibility of parole. In this case, the state is seeking a sentence of imprisonment for life without possibility of parole on count 1. A defendant who receives a sentence of life or imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. In deciding the sentence for count 1, you are authorized to weigh and consider any statutory aggravating circumstance that has been proven beyond a reasonable doubt and any mitigating circumstance that may have been raised by the evidence throughout the entire course of this trial, including the guilt-finding phase, the sentencing phase, or both. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given to the evidence. In addition, the jury is the sole judge of the facts and of the law as it applies to the facts in this case. In arriving at your verdicts, you are to consider the law in connection with the facts. The court is the proper source from which you are to give the law. In other words, you are the judge of the law as well as the facts under the direction of the court. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more statutory aggravating circumstances, which in this case shall be limited to the following. The murder was especially heinous, atrocious, or cruel, and that involved torture or serious physical abuse beyond that necessary to produce death. Heinous means grossly wicked or reprehensible, abominable, odious, and vile. Atrocious means extremely evil, cruel, monstrous, exceptionally bad, abominable. Cruel means disposed to inflict pain or suffering, causing suffering, painful. Torture means the infliction of severe physical or mental pain upon the victim while he or she remains conscious and alive. Members of the jury, the court has read you the statutory aggravating circumstances that the state has alleged in this case. If you unanimously find that the state has proven a statutory aggravating circumstance beyond a reasonable doubt, the law requires you to consider that statutory aggravating circumstance and decide the appropriate punishment in this case. However, you shall not consider any other facts or circumstances as an aggravating circumstance in deciding the appropriate punishment in this case. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by the law, but moral certainty is required, and the certainty is required as to every element of proof necessary to constitute the verdict. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to show the financial, emotional, psychological, or physical effects of the victim's death on the members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to rational inquiry into the culpability of the defendant, not an emotional response to the evidence. Victim impact evidence is not the same as an aggravating circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstance that has been alleged. You may consider this victim impact evidence in determining the appropriateness of the sentence only if you first find that the existence of one or more aggravating circumstances has been proven beyond a reasonable doubt by evidence independent from the victim impact evidence. Tennessee law also provides that in arriving at the punishment, the jury shall consider any mitigating circumstances raised by the evidence. In this case, mitigating circumstances shall include, but are not limited to, the following. 1, the defendant has no significant history of prior criminal activity. 2, the youth of the defendant at the time of the crime. 3, any other mitigating fact that is raised by the evidence produced by either the prosecution or defense at either the guilt or the sentencing phase of the trial. This means that you shall consider any aspect of the defendant's character and record, and any aspect of the circumstance of the offense that is favorable to the defendant and supported by the evidence. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. The defendant has not taken the stand to testify as a witness. He shall place no significance on this fact. In this sentencing phase of the trial on count 1, the burden is on the state to prove one or more statutory aggravating circumstances beyond a reasonable doubt. The defendant has no burden of proof and is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. Do not surrender your honest conviction as to the weight or effect of the evidence, slowly because of the opinion of your fellow jurors, for the mere purpose of returning a verdict. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will deliver the verdict once to the court. If you do not, you unanimously find that at least one statutory aggravating circumstance has been proven by the state beyond a reasonable doubt, the sentence shall be life imprisonment. If you do unanimously find that at least one statutory aggravating circumstance has been proven by the state beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to life imprisonment or to life imprisonment without the possibility of parole. In choosing between the sentences of life imprisonment and life imprisonment without possibility of parole, you shall weigh and consider any statutory aggravating circumstance or circumstances proven by the state beyond a reasonable doubt, or any mitigating circumstance or circumstances. You will indicate the sentence with your unanimous findings or lack of unanimous findings with respect to the statutory aggravating circumstances on the accompanying verdict form. The sentence must be unanimous. The verdict form must be signed by each juror. The verdict form that you will receive reads as follows. With respect to the sentence of the defendant, Jason Chen, on count 1, presentment 315-228, we, the jury, please indicate your unanimous findings or lack of unanimous findings with respect to the statutory aggravating circumstances and your unanimous verdict with respect to the sentence. Do not unanimously find the statutory aggravating circumstance beyond reasonable doubt, and do unanimously agree that the defendant's sentence shall be life imprisonment. Or do unanimously find the following statutory aggravating circumstance beyond reasonable doubt in that the murder was especially heinous, atrocious, or cruel, and that could involve torture or serious physical abuse beyond that necessary to produce death. And please mark one of the following sentences. Do unanimously agree that the defendant's sentence shall be life imprisonment without possibility of parole, or do unanimously agree that the defendant's sentence shall be life imprisonment.